Good afternoon. My name's Helen Mountfield. I'm a judge of the Qatar International Court and the principal of Mansfield College at the University of Oxford, and it's my great pleasure and privilege this afternoon to moderate this session on the role of law, and indeed the rule of law, in addressing the climate crisis, which of course has knock-on effects on many of the other issues which are being discussed today, like food insecurity, the refugee crisis, and the growth of populist leaders. So we have a very distinguished panel to discuss these issues today, and if I can introduce the panelists who will then talk about the role of law in articulating and enforcing the types of obligations which are necessary to address these questions. On my left, right as you look at my left, I have Professor Sir Brian Hopkins, who is the chair of the Grantham Institute for Climate Change at Imperial College London and a world-leading climate scientist. Next to him, I have Justice Mansoor Ali Shah, a Justice of the Supreme Court of Pakistan, and who has been the author of a number of innovative and imaginative judgments on climate justice, which he's going to talk to us about today. Then we have Dr. Muna Al-Marzouki, who is a judge of the QFC Regulatory Tribunal and an Associate Vice President of Qatar University and currently acting Dean of the Law School there. And finally, Lord Thomas of Cumgeath, President of the Qatar International Court, former Lord Chief Justice of England and Wales, and with a string of other relevant roles. He's the chair of the Financial Markets Law Committee in London, of the European Law Institute, and the Standing International Forum of Commercial Courts. So I'm going to start by asking each panelist what, in their view, are the key points affecting the use of courts and the approach which they have taken so far to climate justice. Mansoor, could I start with you and the approach that courts have taken in Pakistan and its neighbouring states?
Thank you very much. Let me at the very beginning distinguish between countries who are not significant contributors of GHG emissions, and they are their strategy is adaptation. So the jurisprudence that's being developed from countries whose area is adaptation is different from countries who are looking into mitigation. So our country, Pakistan, is a very insignificant contributor to the emissions, the greenhouse gases. So our challenge is resilience, you see, climate resilience. And it is in this context that we've applied our constitution and our laws to develop the jurisprudence that we have, which we'll talk about in a short while. But so mainly the courts have come in Pakistan to develop this climate resilience because of the inaction on the part of the government, and the citizens or the residents have come forward to the courts to protect their human rights. So the whole literature or the whole jurisprudence coming out of Pakistan revolves around human rights, which we call fundamental rights under the Constitution. And it is these fundamental rights that we've carved over the years in supporting and developing the climate resilience literature that we have, which we'll talk about in a short while. Thank you.
Lord Thomas, what about the view from Europe, where we are perhaps climate change makers as well as climate change takers?
I think one can say that truly. And what's been interesting...
I think you need your microphone.
Thank you. What's been interesting has been the developments on the continent of Europe. To pick up the theme of this morning's opening, I think where you can characterize the approach in Europe is seeing that promises are delivered, and delivered through the application of the rule of law. The litigation in Europe has by and large come about at the prompting of NGOs and others who've seen litigation as a very important strategic objective of ensuring that people deliver on their promises, particularly the promise in the climate agreement in Paris in 2015. And I think there have been three significant decisions, if I could just mention them briefly. If I can take a decision in the Netherlands and, a little while ago, and one much more recently in France in July of last year, they've looked at using domestic law to make the government adhere to its promises. They looked at the evidence and said, you're never going to get to the climate change goals. We can use domestic law to implement the agreements that were made in Paris. In Germany, a slightly different tack was taken by the Federal Constitutional Court, which looked at the legislation passed by the German parliament and decided that it did not do enough to ensure that there was some equity between the generations. And we can turn back to that, I think, later. But it does seem to me really to emphasize one thing at the outset. Here, courts are not concerned with developing policy. They are concerned with ensuring delivery under the rule of law.
Thank you. And Dr. Omazuki, what about from the context of private actors and private activities? How is the law on climate change affecting their thinking?
Thank you, Judge Helen. So the climate change litigations against private sector has been increased dramatically in the last 18 months or so. There are about 29 cases based on human rights breaches against private sector. So the rise of these litigations means that the risk of litigation, of climate change litigation against this sector and against private entities are also increasing. So the litigation, climate change litigation against such sector aim at influencing the corporate behavior towards more compliance to climate change standards nationally and internationally. And when it comes to the question of who might be the defendants of such cases, who are the defendants in cases against private sectors, we may think that the companies using fossil fuels companies are only the defendants of such cases, or mining companies, or cement companies, any company that are using high emissions of greenhouse gases. However, cases shows that around the world, I mean the litigation database in different countries shows that there are cases based on fiduciary duties of the managers, cases against the financial sector, the due diligence of the failure of managers to take their duty to protect the shareholders and investors, consumers' rights and interests, and for their failure to mitigate any climate change risks. So such claims shows that there are two types of climate change risks, one of which is physical risk, which is the failure to adapt physical infrastructure for extreme weather events. The other type of risk is transition risk. This is the new trend. Transition risk means challenging any construction or financing of high-emitting projects.
Right. Before I turn to Sir Brian, Justice Mansour, I think you've given a couple of judgments in your court on issues which relate to this. Perhaps you could just tell us a little bit about those.
So coming to the judgments from Pakistan, as I said, the jurisprudence that we've evolved, we call it the adaptive jurisprudence. That's not the same as in the West because the issue there is mitigation. So if I could just tell you about the main case that came out of Pakistan, it's called Lagari Case, where a farmer just comes forward to the court, to the Constitutional Court, and says that there is a climate change policy. That's what I want to underline. There was a climate change policy that the state had developed, which was on the shelves since 2012. And there was also a framework for the implementation of that policy, which was also there. There was a ministry for climate change also, but no ground, there was nothing happening on the ground as such. So this farmer comes forward to the Constitutional Court, pressing his fundamental or human rights, saying that I grow crops and I think that the policy is not being implemented, so I don't know what's going to really happen. Drought is going to hit me. What about new plants that we have to develop in the light of the changing climate? And all the other steps that the policy talks about, nothing is happening, and I will just lose out on my livelihood because I'll be totally destroyed. So the court simply, issuing a mandamus to the state or to the government, said that why aren't you implementing your policy? Because by not implementing the policy, you're affecting the right to life, which is a constitutional right, of a citizen. You're also affecting his right to dignity, which is a very strong fundamental right coming out of our Constitution, which is not subject to law, by the way. You can never take away dignity. So right to dignity, right to life. And the government was put on notice to please explain why aren't you taking steps under the policy. The next step what the court realized at that time was that perhaps there isn't much of an understanding on climate change within the government. Because when they came to the court, we saw that their understanding was very limited. So we thought the court must go ahead and try to help the government move on this agenda. And for the first time, we also came up with a concept of setting up a commission, which is a normal civil procedure code thing. You can develop a commission. The court doesn't do that job, but authorizes a commission to do it. And the commission had all the experts there were in the world. For example, the IUCN, the WWF, and other scientific experts were put on the commission, along with some representatives of the civil society, some lawyers. And we told them to go ahead and have a dialogue with the government. They were representatives of the government, and the relevant ministries were there. And the court gave them a target to go ahead and start looking at the policy and see if this commission could help you move on this policy, which to my mind was a very fruitful step, because by the time I left the High Court in a year or so, 60% of the short-term goals that the policy talked about were implemented, and that was because of the judgment that came forward. Another case, which is also about greenwashing, where a private sector company, a cement company, wanted to expand in an area which is water scarce, you see. It was in a valley and it was water scarce area, but they wanted to expand their cement plant. And the government had refused because they thought there's no water, because cement plant requires a lot of water, it's a water guzzler. And they said, no, you can't, it's not in the public interest because there are villages around that area and that's going to be devastating. They challenged that, and that they came before the Supreme Court, and the Supreme Court said no. And that's where we brought in climate change also. We said, no, we need to develop a climate resilient economy. We can't possibly allow you to set up a cement plant or expand the cement plant here because there is no water in this area. And the greenwashing part comes in when the manufacturers would come forward unabashedly and say, well, this cement plant does not use any water, which was very, we thought it was very funny. But we checked around, we got in touch with the experts, and they said there isn't any cement plant in the world that does not use water. So we cut through that chase, and we told them, no, this cannot be done, and they can sort of develop a cement plant elsewhere where there is water, but not in this area. So that's another judgment that comes out, and it also talks about a number of other things. For example, it talks about the future generations. It talks about the fact that this generation is required to do something for climate or to develop climate resilience, because how are we going to be answerable to the future generation? It talks about that intergenerational thing also, which is an interesting dimension which the judgment talks about. And this, for the first time, also talks about giving a legal personhood to nature, which wasn't there in our jurisprudence earlier. Nature now has a legal right. A tree could come forward to court and say, no, you can't cut me down because this is against whatever law or principles there are. So giving a legal personhood to nature is also something that this judgment brings in. But more importantly, it also talks about, and if I could just take a second to explain, it talks about the fact that the judges of the world need to get together on this. I think there has to be a lot more coordination amongst judges. It will really help and coordinate, and if they could just talk about their ideas on this subject, it will be very helpful. Asian Development Bank had done a network of judges and a roundtable of judges on this, which has been very helpful in the Asian context. And I think the judges need to talk about this area. But let me underline, as John had earlier said, we do not interfere in policy. It's not our business what the climate change policy ought to be. That's for the government and the executive to look at. All we're doing is we protect the fundamental rights of a citizen. And while protecting that, we're just simply directing the government to do their job, as has happened in Europe, where Paris Agreement has been pushed into play, and they've been asked to follow the agreement. So that's precisely what we're doing. We're not interfering in any domain of the executive. We're not developing a policy. That's not our expertise. Our expertise is to ensure that the fundamental right of a citizen is protected, and the minute you impinge on that fundamental right, the court reacts, and the court says, no, you can't do this, go ahead and implement the policy. So these are the two cases which I wanted to share with you. Thank you.
Thank you. So Brian, you have the honour and distinction of being the scientist on the panel, surrounded by lawyers. Do we know what we're talking about? Do we have any expertise in this field? And can the courts do anything to address these serious scientific questions?
Well, I'll try and indicate to you that we do know something about this issue, but not everything. And I'll try and raise also some of the areas where I think the law could really make an impact here. I'll resist giving you a climate science lecture, but I thought I should actually give you some indication of where we are. And I thought two sentences which were in the introduction of the latest IPCC Intergovernmental Panel on Climate Change Working Group 2 report. And these sentences, which I'll read to you: the scientific evidence is unequivocal. Climate change is a threat to human well-being and the health of the planet. Any further delay in concerted global action will miss the brief, rapidly closing window to secure a livable future. And that's what we're talking about here. Now, the climate change issue, let's just take a step back. There are many greenhouse gases, but the number one is carbon dioxide, and carbon dioxide from the burning of fossil fuels. And any carbon dioxide we add to the atmosphere will be there for many hundreds of years and will be warming the climate system. So since the pre-industrial revolution, the carbon dioxide in the atmosphere has increased by about 50%. And the temperature of the Earth has gone up by about 1.2 degrees on average, but with differences in different places. While ever we go on adding carbon dioxide to the atmosphere, then the climate system will continue to warm. And it will continue to warm until we stop adding carbon dioxide to the atmosphere. And that's the origin of net zero being the only way to stop the rise in temperature. We also should recognize in timescales that even when we stop the temperature rising, sea level will go on rising for many centuries afterwards. So that is inevitable. So this is the origin of net zero, and also we have the Paris Agreement, and the countries of the world decided that we should certainly stay below 2 degrees for this rise in temperature. Remember, we're already at 1.2, and with a preference to not going above 1.5. So that's the narrow window which we still just have an opportunity to go for, but not for much longer. So if we think about this, then the contributions, the countries of the world through the UNFCCC, the Framework Convention on Climate Change, have volunteered what they think they could do in terms of reducing their greenhouse gas emissions. And if you add all those up, it depends how optimistic you are, but somewhere between 2.5 and 3 degrees is probably what temperature rise those would mean for the Earth, even if they won't go along with those. So we have a situation where the countries of the world are offering a certain amount to do. And then if we look at what happens in those countries, there should be pressure internationally and peer pressure for countries that could do more to do more, because we certainly need that. And that could be externally or it could be internally, and the law could be involved in that. And also big corporations, again, the same pressure. Are their targets right? Are their plans actually up to meeting those targets? And are they realistic? Are they enough? So that's dealing with the emissions of greenhouse gas, sometimes called the mitigation of climate change. But then we come into the impacts of climate change. And climate change means, say, 2 degrees globally, but it means probably 5 times that in the polar region. And it means all sorts of things around the Earth. But the general warming, certainly in the tropics, may make, in certain areas, the planet almost unlivable and certainly unworkable. And sea level rise already 20 centimeters, and the best estimate for the end of the century is something like 1 meter sea level rise. So the slow changes there, inexorable changes are there, but then we come to extreme weather events and the costs of dealing with those, and coping with the ones at present, and then the ones that will follow in the future, trying to make our countries resilient to those future climate change events or to everything else that happens, the attack we're making on our environment. So there's the costs of coping and the costs of building resilient structure. Then the responsibility for that, which has been quite a bugbear in the UNFCCC negotiations, are those who emitted in the past responsible for this and should bear the cost of it. This is often called loss and damages. And you could say there's two periods. There's the period maybe up to the end of the 20th century, perhaps, or rather before that, where people didn't know too much what they were doing, or the period since then. But there's a question of whether there is responsibility to help both with the current extreme weather events and all the hazards associated with climate change, and certainly with the ones in future in terms of making countries resilient. I just finished with a few words about science. Dealing with the law, I was wondering how the law would handle the uncertainty in climate science. Science doesn't deal in absolute truth. It tries to get as close to the truth as it can, but never says this is absolutely true. So, and if you're dealing with the global weather change in temperature or sea level rise, we can be actually unequivocal, as in that statement, that this is due to our activities and in future will be due to activities. When we come to extreme weather events, and perhaps I can say a little bit more about this later, but then the certainty is much less to actually attribute that to human activity. You may be able to say it's 5 times more likely than it was, but that would always be with a certain with uncertainty associated with that science.
Thank you.
Helen, could I just...
yes, of course.
I just wanted to add that, when it's been 30 years that Pakistan has been at it, and we've developed quite a rich jurisprudence, science was something which judges don't understand, obviously. And for the first time, when the environmental cases came to Pakistani courts, it opened the door for science to come into the courtroom. So science and environmental science was so crucial for us judges to understand. And I think in future, if we want to really come up with climate change jurisprudence, or which is adaptive or mitigational, we have to understand science. And it is, the courts went ahead by appointing amicus, by setting up commissions to get experts and scientists involved. So this part of the law, as far as judges are concerned, they cannot possibly decide matters unless they just get a good grip on science. So science has to come into the courtroom if we are to deal with climate change cases. Thank you.
Thank you. I was going to ask you about that, Sir Brian, because you said that science doesn't deal in certainties. But to an extent, nor do lawyers. We tend to be dealing with balances of probabilities, or whether policies have been carried through. And we also deal with problems of causation. And I just wonder how you think scientists can help in courtrooms. Perhaps you have some experience or expertise of how you get
yes.
we non-scientists to
Well,
understand this stuff.
As I hoped I suggested then, there are some things we can be very confident about. But in general, we bring conceptual models of the climate system. We bring computational models on the biggest computers in the world, and we bring those to bear. And we try then to understand, if I take the extreme rainfall, for instance, our best understanding of the climate system, and we're pretty confident in this, is, well, I'm certain in this, that a warm atmosphere can hold more water vapor. It's a very strong effect. If the atmosphere is 6 degrees warmer, it can hold 50% more water, and it usually does. So that means the same rainstorm, if it was 6 degrees warmer, will be 50% stronger. So that's a sort of conceptual, based on physics there. Then the other thing that is done is to take one climate model or a number of them, and to run a control with no increase in greenhouse gases, and to run then a perturbed run with the increase of greenhouse gases, and look at an event similar to the one that's occurred, not exactly the same, and say, well, how frequently did that occur in the one run, and how frequently in the other run? And often you'll find it's maybe 5 times more likely. But that is then in the context of first our understanding of the system, and secondly in terms of one climate model, or maybe more than one climate model, but it is in the context of those models, both conceptual and computational.
Yes. And Dr. Muna, hearing that, I wonder how private companies are thinking about the way climate change is affecting their potential legal obligations and risks.
So the private sectors have to take that very seriously to protect the earth, and they have to be aware of certain grounds for bringing legal actions against them in the courtrooms. And I can summarize some of these grounds that if they are aware of, they have to take them into action, having a corporate strategy to manage and mitigate climate change risk and adaptation. So anyone can bring an action against a private entity if the laws of the state allows or gives the jurisdiction to the courts to hear such cases. So there might be some laws pertaining to climate change, and if they infringe their obligations to take some necessary measures to protect the climate, then they can be liable for that. Or an obligation stated under environmental protection laws, as some states, they don't have a specific laws pertaining to climate change. Or cases could be brought against them based on other domestic laws, such as marketing laws. There are some cases relating to deceptive marketing, when the companies publish about their environmentally friendly initiatives, where in reality they are not. Also, they have to protect human rights, because there are a plenty number of cases, and these are the trendy cases now, mostly based on human rights. The rights of a human to have a healthy and a safe environment to live in, for them, for the current generation, and for the future generation as well. There is an example of a case in Canada where protesters bring a case against one of the private entities trying to block the construction of a fossil fuel company in Canada. Also, they have to respect the penal code in the states, as some acts or omissions relating to climate change amount to a criminal offense. They have to respect their fiduciary duties, because it's also a ground of a legal action against them in case, for instance, of non-disclosure or disinformation to protect the interests of the shareholders and investors. Also, they should respect their code of conduct, as in some companies they do have statements about taking climate change seriously. However, they act in contradiction with such code of conducts and illegal actions around the world. We saw some code of conduct. And interestingly, there is a case against Shell company. It's very historic landmark case. The court ordered in May 2021 against Shell company, and asked the company to reduce its carbon dioxide emissions to 45% by 2030. Although in accordance with Paris Agreement, although this agreement is a non-binding agreement, the court said that the standards internationally underlined under the Paris Convention, considered as international accepted standard by which the company have to bring its action in line with such standards.
Which court was that for the audience?
The District Court of Hague.
Yes.
Yeah.
Thank you. And some of these questions about how decisions are made, or what the public bodies allow private bodies to proceed with potentially environmentally harmful projects, are politically controversial ones. And perhaps, Lord Thomas, can I ask you, do courts have the legitimacy to resolve these questions? And if so, why? And by what right? You need your microphone again.
Thank you. I think it's very important to appreciate that courts lose their legitimacy if they get involved in subjects which they are not either competent or have the right to deal with. And that is why I think Justice Mansour and I are in complete agreement that courts must not get involved in deciding what the policy is for climate change. The legitimacy courts have is to enforce what is agreed. Now, it's right to say, of course, that Paris is sold as a sort of expectation, but I think people have come to appreciate that it's much closer to an international agreement. And national courts have gone about, courts particularly the three of which I've referred, but one can go across the world and see this, that they've realized that if countries are to meet those targets, courts have to take action. That involves a detailed examination of the plans. The illustrations of the three cases I referred to show a very careful analysis. Is the government, by its planning, going to achieve the result? And it's normally subjected to that degree of analysis, and decide, no, it's not, therefore throw it back to the government and tell them they must do something about it. I think it would be illegitimate for them to go any further. And I think in this task, and here I agree again with Justice Mansour, is that it really is important that the judges have a common approach, to the necessity of understanding science. This is why, in a sense, this is an unusual panel. It's not just lawyers, it's scientists as well. And secondly, that we do have a harmonization of approach. I think this is possible because ultimately an analysis we are beginning to do in various areas is showing that we are beginning to adopt the same approach to holding governments to account and to holding private companies to account. So the answer is yes, providing a judge does know more than what a judge's job is, upholding the rule of law.
So it's interesting that you talk about the idea of a harmonized approach, but many of these sources of law, you talked about the Paris Agreement, that's in a sense soft law, and in some jurisdictions, including the one in which you and I practiced, even international law standards that we've signed up to aren't officially part of the law that can be directly enforced by the national courts. So I want to ask you, Justice Mansour, whether there are issues of justice, for example, the justice between states, potentially between different social groups in a state, or even between generations, which are non-justiciable, or whether there are ways for courts legitimately to engage with those questions.
So let me just start off with the legitimacy issue. The principle is very clear, you see. The court's jurisdiction is to enforce the fundamental rights. So if there's ever a violation of the fundamental rights of a citizen, the court interferes. So yes, the court interferes and ensures that the government does and protects the rights of the citizens. The rights could be right to life, right to dignity, right to health, whatever. So it goes on. And we keep on carving. There's a lot of bandwidth in these fundamental rights, because right to life has now been interpreted to mean right to cleaner and unpolluted life and things like this. So we keep on interpreting these fundamental rights. So that's the jurisdiction that we enjoy. But let me just give a little background to countries like Pakistan, which have adaptation as an issue, you see. When we started off 30 years ago, the issue was a local environmental issue. That's how the environmental law developed in Pakistan. It was a local issue in industry. A factory was polluting, and there was a polluter was within my jurisdiction, and I would enforce either the fundamental rights or the local environmental law, penalize the chap, shut the factory down. That was a local issue. And over the years, we evolved. The jurisprudence that evolved was fundamental rights and some of the international principles like sustainable development, precautionary principle, public trust, environmental impact assessment. These principles weaved into the fundamental rights was our environmental justice concept that we developed in the last 20 years. You enter climate change and things change. We do not have the polluter within our jurisdiction. We have nobody to punish. There's nobody in the country that we can punish because the polluter isn't there. So it is the effects and the impact of climate change which is affecting. So it automatically, from environmental justice, we move on to climate justice, which is multi-sectoral. Here, the issue is not punishing a polluter because there isn't one. It is a multi-sectoral thing. We'll have to look at agriculture, how to deal with agriculture. In the context of climate change, we have to deal with irrigation, we have to deal with health, we have to deal with urban planning. So a judge, while dispensing climate justice, has such a broad-based thing. Every time a matter comes before us, we look at whether at all it affects climate change. I mean, this cement plant case that comes up had nothing to do with climate change. Nobody raised the question before us. But we, through our inquisitorial jurisdiction, looked into the matter because we think, even though we follow the common law adversarial system structure, but when it comes to the environment has to win at the end of the day. There has to be an inquisitorial approach that our courts have taken. And even though this was a question that this license should not be granted to the cement plant for the expansion of the plant, would have been a very simple answer. But no, we just went ahead further and we said, come on, we need to come up and make a statement that the country needs to have climate resilient policies. So that's a kind of activism, you may call it, or you may also call it an inquisitorial regime that we follow in environmental matters. So our legitimacy has a very broad range. But coming to Paris Agreement, Pakistan, we could tell the state to follow the Paris Agreement because they've committed, and we could give directions to the government to follow the Paris Agreement. But it would be difficult for us to direct a private party to go ahead and follow a treaty or a convention which has not yet become national law. However, if a case were to come, we could probably still weave it within the fundamental rights and say, originally the fundamental rights are being violated, and then read with the fundamental rights, perhaps Paris Agreement, and even reach out and give a direction against a private party too, but that hasn't yet come up.
So Brian, given what Justice Mansour was saying about the problems of identifying a tortfeasor, somebody who's done something wrong in the context of climate justice, are these issues we should be really trying to look at on a harmonized international level, legally?
Yes, I mean, this is really a difficult problem. As I say, the events we're looking at now have been caused by 200 years' worth of emissions. And so the past is maybe what it is. But the future, I would have thought there's a real vulnerability where those who are responsible for the emissions beyond what they would rightfully do for the Paris targets, I would have thought that those emissions will be fairly obvious. Increasingly, we're able, even from, I think within the next decade, perhaps from satellites, able to give a good measure of what the emissions are from countries, even if they're not owning up to what those emissions are. So there's going to be a good idea of what countries are emitting and big corporations. So those are being monitored and will be monitored. So I think there will be, if the climate as it will be really damaging for people, there is going to be increasing evidence of those who, in the general, are responsible and the events that are happening on the ground.
And before I open it up for questions, Lord Thomas, how practicable do you think it is to build a more harmonized international legal approach to climate, perhaps planetary justice?
There are two things I can briefly say.
You still need your microphone.
First of all, third time lucky. I think there are two things to say. First of all, there is a much clearer desire amongst lawyers in institutions, and if I can give one example, it's the European Law Institute. It's looking at trying to pull together, because of the urgency of matters, a proper evaluation of the best approach. How do you use the national laws to bring about the enforcement of the international agreements? And here the UK, I might probably agree with Helen, is a bit behind the curve. Secondly, it does seem to me that when one turns to private justice, work that is being done, partly led by the legal groups that support the main central banks, and partly by work that is being done by the Standing International Forum on Commercial Courts, it's looking at the private law issues, which Dr. Muna has explained so clearly. And therefore, I do believe that we can't look to any international body to do this. It has to be national judges developing principles that they understand and applying those, and encouraging judiciaries that don't understand the difference between holding governments to account and interfering in policy. Holding governments to account is something for judges. And as long as we have these distinctions approached on an international level, maybe we can encourage those states who are not as ambitious to be more ambitious, particularly as regards private companies, and one hopes governments who are not meeting their obligations.
Yes. And if I may say so, this is something that Justice Mansour was saying, that it's very important, and taking up the theme of the conference from the plenary session this morning, this is where dialogue really matters, because judges who are very expert in their own legal positions can become myopic if they don't look up and out. And on climate justice, this is something we can't really afford to do. Now, I'm going to open it up to...
Just add to that,
Yes.
just one comment. Just want to underline that we're not here to run governments. You see, the judges are not supposed to run governments. Judiciary is not there to run governments. We interfere when there is inaction on the part of the government, or the citizen comes forward saying there is an action on and the government is not performing. So that's one very important thing. It's not for us to get into this debate, and we are not there to resolve this problem. It is for the executive and the governments to resolve this problem. We just simply, as I use the word, jumpstart the government to respond. That is our limited role. So judges should not be taken, or judiciary should not be taken to be providing answers to climate change. We have no clue. We're just telling the government to do that. So that's what I wanted to flag, actually.
Yes, thank you. Now, we have a few moments or minutes for questions. If I have to squint to ask questions, but I think there are two questions there and there. If I could take two questions, and then the panel can answer those.
Thank you very much. My name is Benjamin Phillips. I'm a lawyer in Paris, so I'd like to address a question to the panel. I'm not sure to whom shall I ask the question, though. I'll ask it in general terms. What is your perspective on investment arbitration and climate change, to the extent that massive corporations are usually directly concerned by and protected by bilateral investment treaties, who are not necessarily encompassing climate change policies and clauses? And so at times I think that we have great consideration for climate change, but when it comes to actually legally address it in court, usually courts are deprived from it because the jurisdictions fall under the arbitration umbrella. So what is your feeling, intuition, or understanding of this peculiar situation?
Thank you. And I'll just take the other question too, and then we can, the panel members can address them as they think.
Thank you. My name's Ian Sanford. I'm a practicing international lawyer based in Geneva. A fascinating session. Thank you very much. I was interested in the combination of 4 national court judges plus a climate scientist, and I heard the climate scientist, Sir Brian, say there was a need for international coordination. I think I heard the judges say, and please forgive me if I'm oversimplifying, that the answers at a rule of law level lay in the national jurisdictions and in the work of judges at the national level. My question's a little bit similar to the last one in that it looks at the international plane, and I just wonder if you see any useful role for international courts and tribunals, and I'm thinking in particular of the initiative in the Pacific region that's looking at an advisory opinion on some of the legal aspects, the international legal aspects of climate change.
Thank you. Sir Brian, do you want to start as the non-lawyer in our midst?
I hope there is one, because we need it.
Yeah, Justice Mansfield.
Well, we don't have this issue right now, but there's been a debate that there should be an international court of justice. I mean, an international court for climate. There's been a debate going on amongst a group of judges internationally that there should be one. But responding to the arbitration clause and all, yes, I mean, that hasn't either come up in Pakistan yet. But I would imagine if there is, I mean, for example, there was a company that was shut down on the ground that it was wound up on the ground that it would be environmentally hazardous, you see. So we use the company law of the land, the national law, and we thought that we should wind this company up because this company is environmentally not friendly. So yes, if there is an arbitration clause, I'm quite sure if it comes up before the courts, if the courts, I mean, the judges need to be more aware of this area, they need to understand the science of it. They will interfere, and they should sort of, you know, take it to task, take the parties to task. I don't see a problem with any arbitration clause which deals with climate change is enforced in a local national court should not be a problem. If that was the question that you wanted to ask, I see no problem. It's just that it hasn't come up in Pakistan yet, but I think, yes, it could be enforced. But as far as the international obligation is concerned, that perhaps maybe one day there has to be a court which internationally looks at an issue that relates to a region. We can only be, our jurisdiction is only within the country and we can't do anything about it, but we certainly feel that there should be a court where a party could go, where there are 3 or 4 countries involved, yes, but beyond my jurisdiction in that sense.
Yes. Dr. Muna.
Thank you. I think Judge Mansour nicely answered the questions.
Yeah.
Pass to Lord Thomas. He has anything to add?
I've remembered my microphone this time. I think you raised 2 fascinating questions. If I can take the easy one first, and that's having an international court or system that would decide this. Absolutely. But actually a huge amount of progress has been made in the area of bringing about, both in the human rights area and also in the private law area, working judges, seeing what other judges are doing and doing nationally. And I think in the foreseeable future, that is the way forward. I think the issue on investment arbitrations is actually a very difficult one. Is now beginning to see, earlier this month, or maybe the end of last month, there was a major suit brought against a European state because bondholders were complaining that legislation was imposing enormous costs on them, and they wanted to sue for it. And I can't help feeling that an impediment that we may run into is the change in local legislation, which penalizes what is being done, and one will have investment arbitrations occurring where those who are polluting or not doing enough will seek to have these disputes resolved. They are treaties, and as I believe in the rule of law, one has to hang on to them. But I do hope that actually much more of this is done in the open, because I think the real problem with investor-state arbitrations is the lack of transparency, and that may be the medium-term answer to the problem. But it is, you put your finger on a real problem for the future, I think.
We have about 30 seconds left. I'm going to give the last word to Sir Brian.
Oh, I didn't know it was the last word, but just thinking about the international dimension, up till 14 years ago, to the Copenhagen COP meeting of UNFCCC, then there was an attempt to do top-down and say to countries, you should be doing this. And from the ashes of Copenhagen came the idea of letting countries actually volunteer what they would do. And that then culminated in the Paris agreements and the NDCs we have now. But the problem we have is they don't add up to enough. So somehow we've got to get that top-down squeeze on again. And if international jurisprudence in whatever form can help in that, then that would be really helpful. Can I just add one word too? The Paris target's 1.5 to 2. If that window shuts and we can't do that, we should try and make it 2.1. It shouldn't be giving up. it makes it even more essential to just try and get as close as we ever can. We don't give up, we try even harder.
Justice Mansour cites Marx and says, judges of the world unite. That's Gramsci, pessimism of the intellect, optimism of the will. Thank you very much to my panelists. Thank you all for coming along to a very important session.